Hey, folks, I'm back with another update in Richman v. United States. Where we left off last, the Judge Colleen Kollar-Kotelly, had ordered DOJ to file the Arctic Haze search warrant materials that were taken from Professor Daniel Richman. She ordered DOJ to give them back to Professor Richman, but to also make a copy of all of those materials and file them under seal in the Eastern District of Virginia. And that would allow, one, Richman to get the relief that he's seeking in this civil case. Two, DOJ would retain a copy of all the materials, and they would be under seal in the Eastern District of Virginia, where they would presumably, DOJ wants them so they can use them in a future case against Comey or whoever. And DOJ would be able to get a new search warrant, which is what they should have done earlier this summer, or at least apply for a new search warrant for the materials, get what they wanted out of those materials, and then use it against some future indictment of Comey or whoever else, right? And it seemed like a win-win, to be honest. It seemed like Richman was getting what he wanted, but DOJ was not being deprived of those materials that they gathered during the Arctic Haze investigation some 5+ years ago. And they weren't losing access to them. It was just going to be under seal, and they would have to get a judicial search warrant in order to get material from them, which is what they should have done anyway, like I said. So that was document number 20 on this case. Okay. That was the judge's order right here. And it came with a memorandum right here, which further went into detail of it, which I have not gone over with you guys. And that's what I'm going to do in this episode. But before I go over it, I want to tell you that since then, on December 12th, there's been some 20 more filings in this case. They did not go on Christmas vacation. In fact, there was an emergency motion on Christmas Eve. So things have not slowed down here at all. And DOJ has not quite complied with the judge's order. And Professor Richman has not quite received the relief that the judge granted him. So things in this case where we kind of left off in the last video, it seemed pretty straightforward and simple, like, hey, that's a resolution that makes sense and is also intriguing because it allows DOJ to go on with whatever investigation they're wanting to do, or they're wanting these materials to contribute to, whether it's an indictment of Comey or there's some other thing going on, which I happen to think there's probably some other thing going on. It seemed like we were set up like that was it, but that has not been what has happened. At the same time, Comey has not been re-indicted by DOJ, and instead DOJ has appealed the decision that killed United States v. Comey. And I have it. Here we go. So they filed a notice. I want to see what date it was. It wasn't Christmas Eve. It was just before. There we go. Notice of appeal was on December 19th. So almost a full month after United States v. Comey was dismissed, DOJ has notified the court that they are appealing that case. And I found the docket for the appeal. It is right here. It's the Fourth Circuit Court of Appeals. And we have a schedule for it. It was docketed December 22nd. And I believe filings are due by January 17th or 26th. January 26th is when the opening brief is due. Response by February 17th. And then a brief reply within 10 days of that if they're going to file a reply. So who knows if they're going to wait to the last minute or if they're going to file an extension for it. But this path of appealing the judge's order, which was always a possibility that they would appeal the dismissal of United States v. Comey, and they said that they were looking to appeal it. I actually figured they wouldn't. The quicker and more obvious path, it seemed to me, would be maybe not more obvious. This is just as obvious. But it seemed to me like they might just re-indict Comey and just bring a new case with a new prosecutor or in circumstances that resolved what the case was dismissed for, and just do it all over again, like a fresh start to it. Just a redo. And I don't think it would be successful because of, what is it, 18 USC 3288 or whatever it is. Because I don't think that they can actually bring the case again. Because the statute of limitations have expired. But But that would be another battle that they would go into, right? Doesn't mean they wouldn't try to. They would just have to deal with that. So that's the path I thought they would take. But instead, they've gone for an appeal, which is going to take even longer and is going to push us even further past the statute of limitations, which lapsed back September 30th of this year. So this is a much longer road. And at the same time, you also have Richman v. United States, which at this moment has these materials that they seized from Richmond back in the Arctic Haze investigation. It has them kind of not in limbo, but they're at issue in this case. And I really don't know why. I've thought about this over the Christmas break, which, by the way, Merry Christmas to all of you. Hope you had a good one. I had a good one myself. I don't know why they didn't tell this judge that we're right now working with these materials and they're at issue in a different case, and we want to expedite this, get it under seal and resolve it, and then that way we can get a search warrant for the materials and use them in this other case. Instead, they've gone this road where they're kind of playing a game over here. And I don't mean to diminish what they're doing, but there's a very like chip, like it's not quite a chess game. I suppose it's fair to call it a chess game, but it's like this tit for tat incremental legal maneuvers here on this docket with all these. There's several motions for clarification on little bitty details, and I think the judge is getting quite fed up. So anyway, we're going to get back to the Richmond case. I've kind of gone off. These things are connected, so I haven't gone off trail, but it's difficult to. One of the things that one of the reasons why I haven't done a video in the past like 10 days, besides it just being the holidays and wanting to enjoy that and all the, is because this has gotten not convoluted, but there's so much information that you kind of need to have in mind at the same time to grasp the situation with this case and with the Comey case and then now the appeal, that it's a lot to take in, and then to try and put it back out and represent it is a task. It's not as straightforward as it initially began as, which I'm not too surprised about that. So anyway, Linktree is in the description, and it's also in my profile wherever you're watching or listening to this, and there you can find all the places to follow, watch, listen, and support the show. Thank you to everybody who has supported the show over the course of 2025. Really appreciate you guys, and I look forward to 2026. And yeah, let's get to this. So where I want to go, this is the order that I went over back on December 12th is when this came out, and it told the government that, hey, you seized all this stuff. You seized material from Columbia University email accounts of Professor Richman and his Apple iCloud account, and you also got his phone and his PC, and these are collectively called the covered materials, and you are ordered to return those things. The motion for return of property filed by petitioner Daniel Richman is granted. The United States is also ordered to prepare a single complete copy of all of those covered materials and file it under seal in the EDVA, where it can remain for future access pursuant to a lawful search warrant and judicial order. And it's ordered that the government shall return to Mr. Richman all copies of the covered materials, except for the single copy that is going to remain deposited with the court. And it's ordered that the Attorney General shall comply with this by Monday, December 15th. Some 10 plus days ago. Now, in her order, her memorandum that went along with this, she takes the time to go through it in much greater detail. And I've gone through this a couple times, but I haven't made a video about it. I skipped over it in order to get to some of the briefer filings. But in this video, I want to spend some time here. And one of the reasons I do is because all the rest of the stuff that happens on this docket since then these are continue to reference the docket order over and over and over again, because that's the big issue here, that they've made this order. And it's not that DOJ is so much rejecting her order, it's that they're filing over and over again for clarification. And then now on December, or on Christmas Eve, a motion for an extension for a stay, for an extension of time. Not stay, an emergency motion for an extension of time in order for them to comply. And Lindsay Halligan continues to be on the filings here for the EDVA, even though she is not, or for DOJ, even though she is no longer the qualified attorney for the district. Which, by the way, I don't think she's going to win an appeal. They recently gave up on Alina Habba. I think DOJ's in the wrong. They're in the wrong on this interim appointment thing. That's another reason why I don't quite get them appealing it, because they're going to lose. They're going to lose. Okay. As promised, the judge's redacted memorandum. Okay. When the government violates the Fourth Amendment's prohibition on unreasonable searches and seizures by sweeping up a broad swath of a person's electronic files, retaining those files long after the relevant investigation has ended, and later sifting through those files without a warrant to obtain evidence against someone else, what remedy is available to the victim of the government's unlawful intrusion? A fantastic question. That's what's happened here. I hope everybody realizes this. That what DOJ did, you please set aside your opinion of Comey. Set aside your opinion of Comey and everything. Just set all that aside. It is a fact that DOJ during Arctic Haze, that those investigators took more from Professor Richman than what the search warrants authorized them to seize. They took more than what they were supposed to take. They took from a longer timeline than they were allowed to. The window, each search warrant said from anything fitting the description of the search warrant materials it was aimed at, and that exists between this date and this date. And they went outside of that. They went broader and deeper than what the search warrants allowed them to do. That's infraction number one. Infraction number two is that they seized attorney-client privilege materials from Richman. That's infraction 2. Infraction 3 is that they did not segregate those things from the materials they were actually after. And they never did segregate them until just now. They had them mixed together for 5 years. Infraction number 4 is that they never went to the clients that were in those attorney-client privilege materials and allowed them to go through a filter process to assert their rights over those materials, their privilege over them. Infraction number 5 is that they did not get a new search warrant to go through this material when this summer they opened up an investigation into Comey. Infraction number 6 is that they used material seized from Richman pursuant to an investigation that was to do with the taking and transmitting of national defense information, and then use those materials or that they took from here to indict another person for completely different crimes, for obstruction of Congress and for a false statement to Congress. That's what DOJ has done here. And if you can set aside who these people are, you can set aside your own bias, whatever it may be, for or against Comey, for or against Richman, for or against, just forget the hearing, forget everything in the United States v. Comey, and just a person's electronic files. Government keeps them for 5+ years, misuses them, doesn't segregate them appropriately, doesn't arrange them to protect attorney-client privilege, and then later, without your knowledge, goes through those materials without a new search warrant to obtain evidence against someone else who happened to be your client communications between you, an attorney, and your client, and then uses those to indict someone. What remedy is there for such an unlawful intrusion? Federal Rule of Criminal Procedure 41G provides one such remedy. A court may order the government to return the files to their rightful owner. This case calls for that remedy. Petitioner Richman, Daniel Richman, an attorney and law professor, challenges the government's retention and use of certain files that the government copied from his personal computer and online accounts between 2017 and 2020 in connection with investigations of potentially improper disclosures by James B. Comey, a former director of the FBI. Petitioner Richman argues that the government's ongoing retention and use of these files violates his Fourth Amendment right to be free from unreasonable searches and seizures. He therefore asked an order directing the government to return the files to him. Petitioner Richman also applied for a temporary restraining order to limit the government's ability to use the files at issue while this matter is pending. This court partially granted the petitioner's application for a temporary restraining order to preserve the status quo as it awaited a formal response from the government. And I think that's what most people know about this case. I think what most people, casual news observers, and maybe somewhat active news junkies, probably like yourself, what most people know about this case is that Richman, person 3 from the Comey case, Comey's friend, who Comey leaked through, allegedly, went to a judge in D.C. and got that judge to restrict DOJ from investigating his friend. And got a temporary restraining order. Grr, what a mean judge, what a crooked judge. Grr, what a crooked person Richman is. Grr, how crooked Comey is. And that's basically the extent of what people know about this case. Grr, the court system is protecting Comey. It's all deep state. But we know a little bit more, don't we? Because we're going to the documents. The government has now appeared in this case, and it opposes Richman's request for a return of property and moves to dissolve the court's temporary restraining order. The government argues that petitioner Richman's motion amounts to nothing more than an improper collateral attack on the investigation and prosecution of Comey, and that return of the property to Mr. Richman is not an available remedy. Not just that it shouldn't happen, but that this is not a remedy that's an option for him. He literally legally can't get it. Upon consideration of the party's submissions, the relevant legal authority, and the entire present record, this court agrees with petitioner Richman that the government's retention and use of his files has violated his Fourth Amendment rights. And this is not the first judge to see it this way. If you follow United States v. Comey with me, then you know that. Specifically, the government's retention of an image, meaning a forensic image, of petitioner Richman's personal computer, that is a complete copy of all the files stored on the computer, including backups of his phone and tablet, and its retention of related materials from his online accounts for years after the conclusion of the relevant investigation, is an ongoing unreasonable seizure. This seizure is unreasonable because the government's warrantless search of the files earlier this year reveals that the government has not implemented effective safeguards to protect copies of files from unlawful access while they remain in the government's custody and control. That's what I was going off about earlier, the infractions. The court also agrees with petitioner Richman that the government's conduct reflects a callous disregard for his constitutional rights, and each of the other prerequisites to this court's exercise of equitable jurisdiction to order the return of property are satisfied. Because petitioner Richman is entitled to the return of his property as a remedy for the violation of his constitutional rights, the court is unpersuaded by the government's contention that his motion must be denied based on its potential collateral effects on the investigation and prosecution of Comey. In other words, the government can't sit here and say, but judge, if you stopped us from illegally accessing or improperly, to put it more kindly, accessing these materials we shouldn't have in the first place and using them to indict this person that we didn't properly investigate either, It's going to mess everything up, Judge, so please don't do this. It sounds silly, honestly. Like, no, you can't. You shouldn't have had it in the first place. You shouldn't have used it in this way. You went about this whole thing wrong. You went about the entire thing wrong. You put a never mind. I'm gonna stop. Accordingly, to remedy the government's violations of Petitioner Richman's Fourth Amendment right against unreasonable searches and seizure, the court shall grant his motion for return of property, order the government to return to Richman the image of his computer that was made in 2017, any files obtained from his Columbia University email accounts, or his Apple iCloud account in 2019 or 2020, and that are in the government's possession, or any copies of the images or files obtained from Richman and his iCloud account, any materials directly obtained or extracted from those files that are in the government's possession. Those are going to be called collectively the covered materials. In order to protect access to the files at issue and preserve their availability for lawful use in later proceedings, and as an exercise of the court's equitable discretion to fashion a remedy that is appropriate under all circumstances, the court shall further order that before returning the covered materials to Petitioner Richman, the government may create one complete electronic copy of those materials and deposit that copy under seal in the Eastern District of Virginia, which shall have supervisory authority over access to this material for future access pursuant to a lawful search warrant and judicial order. The U.S. EDVA may then exercise its discretion to decide whether to allow Petitioner Richman an opportunity to move to quash any such warrant before it's executed. I don't think this is splitting the baby. I think this makes the most sense for everybody. Okay. And then he gives us some background, which we already know the background. I do believe there was something here that was new. And there's this there's this redacted portion here. It says, after this hearing, it's talking about June 2017 when Comey testified that he asked a friend to share the content of a memo with a reporter. After the hearing where Comey testified, Petitioner Richman allowed the FBI to create an image, meaning a forensic copy of his hard drive, all the files on his personal computer and a hard drive attached to that computer. So it's not just one hard drive, it's two. It's the personal computer's hard drive and then an external hard drive, which included backup files containing the contents of his cell phone and his tablet. Petitioner Richman authorized the FBI to use that image for a limited purpose. Okay. We haven't seen what the agreement was. Considering this wording right here, there's something that was signed. There's some document that says, I, Daniel Richman, permit the FBI to such and such and such. And within that document, it describes a limited purpose that they can use what's on that computer for in that hard drive. And then we get this redacted section. We don't know what it says, but there's a footnote. The footnote says, the factual material in this paragraph and the latter half of the preceding paragraph was provisionally filed under seal. If that material is later unsealed, the court will unseal this portion of its memorandum opinion. Very interesting. We will be looking for that to happen. Okay, then it goes on to talk about 2019 and 2020 investigation. So remember, this is something that's kind of easy to forget or overlook here, is that the government got a forensic image of Richman's PC and external hard drive, not pursuant to a search warrant, but pursuant to an agreement with Richman. He volunteered it. And this was part of the DOJ looking at memos that Comey had sent out after he had been fired. That is separate from Arctic Haze. Arctic Haze comes about in 2019 and 2020 in connection with the government's search for who leaked national defense information to the New York Times and other outlets. And when they were looking for that, they went to Mr. Richman, and that's where they had the 4 search warrants. Okay. The rest of this we already know from the Comey case. I'm just going to assume that anybody watching this video paid attention to the United States v. Comey. If you didn't, I have a playlist for it. Let me see. Yeah, I don't think I need to go back over this material with you guys. Actually, I've changed my mind, because as I've read further into this, it gives a description of some of the search warrants in Arctic Haze that we haven't had before, or at least are worth stating again. And this judge has seen the Arctic Haze search warrants, and she's describing them here. And I think this is going to become. I think there's a very important thing to understand here, which is, should the government try to re-indict Comey on the same charges, it's going to fail again, because they shouldn't have access to this material, because it is attorney-client privileged, and it was unlawfully searched by the government over this past summer. So it's just another way in which the case against Comey fails, and that they mucked it up. Whether you think that was purposeful or not, they mucked it up. All right, so this says, in April 2017, a major newspaper published an article where, this part, this is the New York Times, where they said that a major newspaper published an article that allegedly included classified information about a factor that influenced Mr. Comey's decision to announce publicly that the FBI closed its investigation into Hillary Clinton's use of a private email server during her tenure as Secretary of State. This article quoted Richman by name and identified him as a confidant and friend of Mr. Comey. Soon after this article was published, the government began an investigation into the public disclosure of the allegedly classified information that had been included in the article. The FBI called this investigation Arctic Haze. In connection with this investigation, between August 2019 and June 2020, the FBI and the U.S. Attorney's Office for D.C. obtained 4 warrants to search Petitioner Richman's electronic files and communications. The first warrant, issued in August 2019, authorized a search of the hard drive containing the image of Petitioner Richman's computer that the FBI had made in 2017. The second warrant, issued the following month, authorized a search of 2 Columbia University email accounts that Petitioner Richman used. The third warrant, issued in January 2020, authorized a search of Petitioner Richman's Apple iCloud account. The fourth and final warrant, issued in June 2020, authorized a second search of the hard drive containing an image of Petitioner Richman's computer. And you see right here, it has Petitioner's Exhibit D, Petitioner's Exhibit B, all of those. Those are these right here, filed under seal by Richman. Those are the search warrants, I believe. And you may recall that in United States v. Comey, it was ordered that those search warrants be unsealed. It would appear that did happen. But they're filed here, or at least they actually, I shouldn't say that. I don't know that happened. I feel like if they had been unsealed, we would see those here. Instead, they're also sealed in this case. Anyway, all 4 warrants were limited in scope to allow seizure of only information relevant to 18 U.S.C. 641, 793D, and E, criminal statutes concerning the theft and conversion of public records and the mishandling of national defense information during specified periods. Petitioner's Exhibit A, which is this right here, which is that first search warrant, limits the seizure to information, quote, to information that constitutes evidence and or instrumentalities of violations of these statutes right here, which are not what Comey was charged with in United States v. Comey. Petitioner's Exhibit B is the same description. Petitioner's Exhibit C, the third search warrant, same thing. It limits the seizures to information relevant that constitutes evidence of violations of these statutes here. And then Petitioner's Exhibit D says it limits seizures to, quote, data and information that constitutes fruits, evidence, contraband, or instrumentalities of violations of those same statutes, which again are not the statutes that Comey was charged under. One of these warrants also contains an express limit on how the government would use the information seized. The first warrant, authorizing a search of the image of Petitioner Richman's computer, provided that, quote, after determining which information is within the scope of the information to be seized, under the terms of the warrant, the responsive information may be copied and retained by the United States. But information that was not within that scope of the warrant would be sealed, and the government would not further review the information absent a court order. Uh-oh. What did they do this summer? They did exactly that, didn't they? They reviewed it without a court order. Petitioner Richman asserts, and the government does not dispute, that the image and online accounts targeted by these warrants contained a trove of personal and professional information related to the Arctic Haze investigation, some of which was highly sensitive and highly personal. Among other things, the materials included a significant quantum of attorney-client privilege information, including or involving multiple clients. Recognizing the potential privilege issues, the government allowed Petitioner Richman to review warrant returns for 3 of the 4 warrants to assert claims of privilege, but not all 4. With the assistance of counsel, Petitioner Richman reviewed these returns, withheld privilege material, and produced privilege logs to the government. However, for 1 of the 4 warrants, the first one, which authorized a search of the image, the forensic image of his personal computer, the government did not give Mr. Richman an opportunity for such a review. Richman was therefore unable to assert claims of attorney-client privilege over this material at the time the government collected it for use in the Arctic Haze investigation. In addition to privileged material, the image and online accounts that the government collected in the Arctic Haze investigation included sensitive correspondence related to student and faculty appointments, Richman's personal photographs, his personal medical information, and all of his application data. Collectively, these materials are, quote, a complete record of Petitioner Richman's electronic life up to the date of the seizures. The government closed the Arctic Haze investigation in 2021 without filing any charges. In September 2025, 4 years later, in the course of a new investigation into Mr. Comey, led by the FBI and U.S. Attorney's Office for the Eastern District of Virginia, the government conducted a further search of Petitioner Richman's files. Inexplicably, the government did not seek or obtain a new warrant for this search. For this search, an FBI agent was instructed to review a Blu-ray disc that contained a full Cellebrite extraction and reader reports for 2 of Petitioner Richman's devices to identify conversations between Richman and Comey. The U.S. Attorney's Office for the EDVA advised this agent that the FBI was legally permitted to review the information contained on the Blu-ray disc. It appears from the record that there were no precautions in place to avoid the collection of privileged communications during this initial review. During that review, the assigned FBI agent found text messages between several people, including Mr. Comey and a Michael Garcia. The agent did not recognize some of the names, including Garcia, and could not determine whether the messages were relevant to the FBI's investigation of Mr. Comey. Nonetheless, he printed the messages for another agent to review and returned the Blu ray disc to that agent. Upon review of these printed messages, the second agent concluded that Michael Garcia was an alias for Petitioner Richman, and he determined that some of the messages between Petitioner Richman and Mr. Comey may be covered by attorney-client privilege. About 2 weeks later, on the day that the government presented its case against Mr. Comey to the grand jury, the second agent provided a, quote, limited overview of the messages between Richman and Mr. Comey to the lead FBI case agent assigned to the case and an attorney from the FBI's Office of General Counsel. The agent also advised lead case agent and the OGC attorney that some of the messages between Professor Richman and Mr. Comey that the agents had reviewed, quote, appeared to reference potential future legal representation. There should have been like alarms going off right then. Alarm. The OGC attorney immediately advised that any of the text messages referencing potential future legal representation should not be part of the indictment preparation. After this discussion, the lead case agent proceeded into the grand jury and testified as the sole witness in support of the pending indictment against Mr. Comey without waiting for a filter team to establish or for the privilege issue to be otherwise resolved. 18 days later, after the grand jury voted to return a true bill on 2 of the 3 counts the government had presented, the government approached the U.S. District Court of Virginia to propose a filter protocol for materials that the FBI case team had already reviewed. A story of screw up after screw up, right? It's terrible. I mean, it's almost like the person running the investigation and running that prosecution had never been a prosecutor before. Okay, we can skip this part. Analysis. Although no party contests this court's Article 3 jurisdiction, the judge goes over it anyway, which makes sense because this might get appealed at some point. That might come up. I don't know. Next part. To obtain the return of his property under Rule 41G, Petitioner Richman must show the property seizure was illegal. Richman contends that the government's seizure of his property violated his Fourth Amendment rights in at least 3 ways. 1, the government exceeded the scope of the prior warrant. 2, he argues the government has continued to retain his materials for an unreasonable period of time. And 3, he argues that the government executed an unreasonable, warrantless search of the retained property. The court will address each of Richman's arguments in turn. The court concludes that although the government's initial seizure of Richman's property and its continued retention of that property did not violate Richman's Fourth Amendment rights, the government's warrantless search of his property in 2025, approximately 5 years after the initial seizure, did violate those rights. The court further concludes that the government's mishandling of Richman's property renders its continued retention of that property an unreasonable Fourth Amendment seizure. Huge. These are huge findings by this judge. And they would prevent, I mean, they kill the chance of re-indictment of Comey unless the government can get a new search warrant for those materials. On the present record, Mr. Richman has not shown that the government's initial seizure, it wasn't illegal back then. And Richman doesn't contest the validity of the four search warrants. According to Richman, the government violated the terms of the search warrants by failing to identify and segregate responsive data. Richman's claim of overseizure is based on recent findings made by Magistrate Judge William E. Fitzpatrick in the United States v. Comey case. The court adopts Magistrate Fitzpatrick's findings from the record. Boom. Remember those 11 findings? I have a video going over that in United States v. Comey. And the videos on Rumble and on YouTube, where I go over each one of those findings that are absolutely horrible for the case anyway, for DOJ. Let's see. Magistrate Judge Fitzpatrick's findings establish a reasonable basis for Petitioner Richman to challenge the government's seizure of his property. Yeah, this is good information here. We already know there's other findings from previous video, but right here, this judge makes a really good point and raises an issue that hasn't gotten a lot of attention. Magistrate Judge Fitzpatrick's findings show that Petitioner Richman's former attorney wrote a letter to the government claiming that the DOJ had informed Richman that its seizures under the Apple warrant and one of the hard drive warrants contained property that fell outside of the temporal scope permitted by those warrants, meaning they took more, like it had, remember I said it had a date, material existing between this date and this date, and they went beyond that by months. If this is true, then the government would have exceeded its scope of authority under those warrants. Furthermore, Magistrate Judge Fitzpatrick provided the government with multiple opportunities to dispel concerns regarding its seizure under the warrants. But rather than offer any insight into the scope of its seizure under the warrants, the government simply said it did not know whether the responsive materials were separated from the non-responsive materials. Meanwhile, counsel for the defense reviewed the materials seized by the government and informed Magistrate Judge Fitzpatrick that the manner and format in which they were provided did not reflect the separation of non-responsive materials. Because the government has the most insight into its own execution of the warrants at issue and has not been forthcoming with respect to the information seized from those warrants, the court shall take the government's failure to augment the record as further support of Magistrate Judge Fitzpatrick's findings. So they still haven't corrected for this. They're just not admitting it, is what's going on. They're just not admitting that these materials, that they messed up. They're not admitting that they messed up with the original search warrants. They messed up by how much they seized, the depth and the breadth of what they took. They're not admitting that. They're not admitting that they messed up by not segregating it. They're not admitting that they messed up by not giving due attention to the attorney-client privilege materials and separating those. They're just acting as if they haven't been asked about it. How many times I'm going to hit my microphone this episode? A lot. Okay. The court determines that, or the court shall not determine whether Petitioner Richman has conclusively established a violation of his Fourth Amendment rights, however, based on his claim that the 2019 and 2020 search warrants at issue were overbroad. Magistrate Judge Fitzpatrick's findings raise a substantial question. Blah, blah, blah. The court notes his ruling is limited to this ruling here is limited to Petitioner Richman's claim regarding the government's alleged overseizure of information. This ruling in no way undermines the court's analysis of Richman's Fourth Amendment claim. Accordingly, the court concludes, based on Magistrate Judge Fitzpatrick's findings and the present record, Petitioner Richman has shown a reasonable basis for his claim that the government violated its Fourth Amendment rights by seizing more material than was authorized by those 4 search warrants. However, because the parties have not supplemented the limited record with additional information regarding the government's seizures in 2019 and 2020, the court shall refrain from making a conclusive determination as to whether these seizures exceed the scope of their warrants. So she's saying that I don't have enough information from the parties here about the material seized, about the search warrants, so I can't make that determination. But I can make the determination that the petitioner has shown a reasonable basis for that claim. Okay. Let's see. This is about the government not protecting the files, which they didn't. They didn't. Okay, so these rules about how the government is to maintain and protect evidence they seize. These rules are often relatively straightforward to apply in the context of physical property, but their application can become more complex in the context of electronic data. To what extent does a person have a possessory interest in copies of electronic files if other copies saved elsewhere remain available? When does the government retention of those files interfere with that interest? There are two prior decisions from the district that provide helpful guidance on this issue of whether and under what conditions the government may reasonably retain and use electronic data seized under search warrants issued in a previous investigation. In summary, the Fourth Amendment does not categorically prevent the government from retaining data under these circumstances, but the government must obtain a search warrant before returning that data in a subsequent investigation. And that is where they messed up big time in United States v. Comey. She goes through some other decisions, which are interesting, but we get it. Okay, applying everything above in those court cases, the court concludes that it was reasonable for the government to retain Richman's files after it closed the Arctic Haze investigation, but only so long as the government adequately protected those files by refraining from accessing or searching them without a warrant. Although the government's initial seizure of these files swept up a significant volume of material that was not responsive to its investigation, seizing and retaining all of that information was reasonable considering the practicalities involved in the seizure and forensic analysis of digital data. That seizure did not become unreasonable because of the conclusion of the government's investigation, so long as the government had a legitimate purpose for retaining Richman's files. However, given the exceptionally sensitive nature of the files, Richman maintained a possessory interest in them, including an interest in exercising the right to exclude by deciding who could and could not access copies of them. Richman did not relinquish that interest by consenting to limited searches of the files in 2017. Remember, when there wasn't a search warrant, he disagreed. Yeah, you can make a copy of my computer. On the contrary, the government, or the carefully circumscribed terms of his consent to those searches, which we haven't seen that document, but she's describing them as carefully circumscribed terms, that he was actively asserting his right to decide who could access the files and on what terms. After the government closed the Arctic Haze investigation in 2021, the strength of the government's interest in retaining the files diminished, but it was not categorically unreasonable for the government to retain the files, so long as the government maintained appropriate safeguards against improper access, which obviously they did not. Most importantly, the government could not reach the retained or search the retained files without obtaining a new warrant, which they failed to do here. So long as the government respected that critical limitation, its intrusion on Richman's possessory interest was limited, and retention of the files was reasonable. However, the situation changed meaningfully when the government conducted a recent search of Richman's files, as the court discusses in the following section. Okay, the government's warrantless searches, or warrantless review of the files, whatever you want to call it. Same thing. The core of Richman's claim in this case is his undisputed and unrebutted charge that the government recently conducted a warrantless search of his files in furtherance of a new investigation of Mr. Comey in the Eastern District of Virginia. Specifically, the record shows that in September 2025, the government directed one of its agents to review a full extraction of the data from Richman's cell phone and tablet to search for messages that Richman exchanged with Comey. Although the government, in a single footnote, broadly, quote, denies that there has been any violation of the Fourth Amendment, it has presented no substantive argument that this warrantless search of Richman's files was consistent with or even cognizant of his Fourth Amendment rights. Recognizing the extraordinary scope and sensitivity of data available on personal digital devices, the Supreme Court has commanded that officers must secure a warrant before conducting a search of data stored on cell phones, except in rare cases in which exigent circumstances make a warrantless search reasonable. Moreover, it is well established that the government seeks, or if the government seeks to conduct, wait a minute, no, that's not what it says. Moreover, it is well established that when the government seeks to conduct another search after it has finished executing a previous warrant, it generally must secure another warrant. These requirements reflect familiar bedrock Fourth Amendment principles. Searches conducted outside the judicial process without prior approval by judge or magistrate are per se unreasonable under the Fourth Amendment, subject only to a few specifically established and well delineated exceptions, which those don't apply here. In short, the government's warrantless search of the contents of Richman's cell phone and tablet in September 2025 was manifestly unconstitutional. Another huge finding by this judge in this order. The government's unlawful search of Richman's files in September 2025 falsifies a core assumption of the general rule that the government may retain copies of digital devices after closing an investigation. The critical assumption is that the government will maintain such files with effective safeguards against warrantless searches. The government's faithful adherence to the warrant requirement is the essential element that protects an investigation subject from general unrestricted rummaging through the immense trove of information stored on digital devices. If the government cannot be relied upon to prevent such invasions, its retention of the subject's digital data significantly intrudes on the subject's possessory interest in protecting that data from unlawful and unwanted access. At that point, its retention of a subject's data is properly analyzed as a Fourth Amendment seizure. The court must therefore consider whether the government's failure to protect Richman's files from warrantless searches makes it continued retention of those files an unreasonable seizure. Under the circumstances presented here, the court concludes that it does. Another huge finding. In sum, the court concludes that Richman has shown that in September 2025, the government conducted an unreasonable search. It was a warrantless search of his files. The court further concludes the government's retention of Richman's files amounts to an ongoing unreasonable seizure, and therefore the court agrees with Richman that the government has violated his Fourth Amendment right against unreasonable searches and seizures. And so they order the court to return that property to him. Okay, let's see if it says anything else about, well, anything else of interest to us. A lot of this is, we already know it. We know it from United States v. Comey. But another judge looking at this, I mean, it just shows how the judges in United States v. Comey got it right. As concerns these facets of the case and Richman's property and the government's use and violations. Let's see if there's anything else I want to present to you guys. Okay, the rest of the order, she goes through why she's not granting Richman's request for the government to be restrained, be prevented from using the materials again against Comey. And she goes through the balancing of how she's balancing the interest of both parties, Richman and DOJ. And so Richman gets his property back, but the government gets to keep a copy of it because originally it was lawfully seized pursuant to those search warrants. However, the government must get a search warrant, a new search warrant for those materials if they're want to look into them for a case against Comey or against anybody else or in any other investigation. They have to go about it by the proper way. And so that's the balancing that she's going to do here. And then she's going to have those materials filed with a third party, the U.S. District Court for Eastern District of Virginia. And that's where she's striking a balance between it all. It makes sense to me. I'm not sure exactly how many times something like this has been done, but it makes sense to me. And what can happen then is if the government gets a search warrant for them, gets information from those materials for a future prosecution of Comey, where they refile the case or however they go about it, Comey can then file a motion to suppress, and they can have a new argument about that evidence and where it comes from and whether or not the government should be able to use it against Comey. All that stuff can play out the way it normally would in a criminal case, where you can suppress the evidence against you, or you can argue that it should be suppressed, meaning removed. It shouldn't be available to them. So that's the rest of that order. Now, since that happened, let's go right here. There's been a motion to clarify, and then a sealed memorandum opinion filed, and then extension for the timeline and the motion to clarify, which I already presented in the last video. I went through some of those, but they've continued. And I'm going to check real quick and see the last one I went over in the last video. Okay, so in the previous video, I went all the way up to this one, docket entry number 30. So the next 10 filings are them going back and forth about clarifying things, and the government saying, oh, but we're not sure whether or not you meant that AG Bondi actually had to show up to court. Like, it was kind of silly, to be honest. And the judge slapped him around a bit. Like, she was not happy with the way the United States DOJ was going about this. And then this happened December 18th and 17th. DOJ files this supplement to their emergency motion. It says the court ordered the government to file a supplement to its previous emergency motion to recommend best practices for the safekeeping of the materials that it's been ordered to deposit in the EDVA. And they're like, we got some of this stuff is classified. There's at least one classified document amongst the material that we're going to be filing. And we need there to be a chain of custody because we plan on possibly using this stuff at some trial. And that's going to be in question. What is the chain of custody of this evidence? And so DOJ filed these materials with the litigation security group, which is part of the DOJ, whose job it is to deal with those materials. How do I say it? That's what they're for, is to secure evidence or materials that could be used in a civil or criminal proceeding. And that's their recommended practices of how they're going to handle it. But the thing is, they didn't file it with the EDVA, which is what they were ordered to do. And then they filed this one saying, hey, by the way, it's going to take a long time to make a copy of the covered materials that you've ordered us to make a copy of, because there's over 1 million documents and it's all electronic data, and it's going to take a long time for us to copy it over to a different drive. So can we have your permission to go ahead and start on that? Which it seems like permission was implied when she told them to do it, right? So she gives this order here, which is a minute order. So it's just like written on the docket. There's not a document that gives it. And she goes over what she's already ordered and then what the government said back. And she's like, as of this date, the government has not certified its compliance with our order, the same order we just read. Accordingly, the government is still under a court order that prohibits it from accessing Richman's covered materials or sharing, disseminating, or disclosing those materials. As the government admits, the government provided a copy of Richman's materials to the Chief Information Security Officer after the government filed its emergency motion, in which they represented that they would continue to comply with their obligation to not access these materials. 3 days after the government lodged a complete copy of Richman's materials with the Chief Information Security Officer, and this is the person in DC, not EDVA, the government moves the court to order that a complete copy of the covered materials be lodged with the the Department of Justice Litigation Security Group. The government does not explain this position any further, but it appears to be arguing that the copy of Richman's materials that the court initially permitted the government to deposit with the district court in the EDVA should instead be deposited with the DOJ's Litigation Security Group. The court would benefit from more briefing on what exactly it is that you guys are doing here. Accordingly, the court orders Petitioner Richman to file a response and for the government to explain themselves, basically is what she says. So things start getting weird here and maybe a bit convoluted because the government is not complying. Instead, they're doing something else, and then they're kind of doing that thing where you act first and ask for permission later. So the government comes back and they file a second emergency motion for clarification and extension of time to certify compliance with the order. And they say, yeah, we know that on December 12th, you ordered us to do this thing, and we didn't do it. And December 15th, we filed an emergency motion for clarification because we were confused. And we told you we were prepared to deposit a copy of the materials, which appeared to include classified information, with the Chief Information Security Officer in the United States District Court for the Eastern District of Virginia, which confuses me right off because we just looked at a document where they're saying, and we have the court's permission to begin making a copy of the covered materials because it's going to take a long time. We're trying to comply with your order as far as possible, but there's a million pages of there's a million documents here. It's going to take a long time for a computer to process it. And so we need your permission to access it in order to make this copy. It's like, wait a minute. You already said that you had a copy and that you were, quote, prepared to deposit a copy with the relevant materials in the EDVA, but you still haven't done it. Shortly after filing that motion in an effort to comply as far as possible with the court's order, the government delivered an electronic medium containing a complete copy of the covered materials to the Chief Information Security Officer in DC, who informed the government that they would maintain that copy on behalf of the CISO in Virginia. The government has since been informed by the Department of Justice Litigation Security Group that there is no single classified information security officer for the EDVA. It is the government's understanding that the Department of Justice Litigation Security Group is generally responsible for the maintenance of classified materials on behalf of the federal courts, and that the Litigation Security Group supports the federal courts regarding that subject in civil and criminal litigation. Consequently, it is not clear to the government that the above described electronic medium could properly have been provided to the clerk for the EDVA, particularly given the extreme time pressure created by the deadlines in this case. And then also, Judge, there was some lack of clarity regarding these materials. The December 12th order, what is not clear about this? Okay, I went over that in the past. Okay. The court stated additionally that the government would be required to certify compliance with the December 12th order with specificity and clarified the modified blah, 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 blah. The court has not yet otherwise explained whether the government must provide to Richman the original evidence obtained in the Arctic Haze investigation, whether the government must provide Richman with covered materials in some other fashion, and what else the government must do to comply with the December 12 order. Notwithstanding the passage of time, changes in personnel, and the limits of institutional memory, the government emphasizes that the materials at issue have at all times remained subject to DOJ standard evidence preservation, record retention, and chain of custody protocols. The government is not aware of any destruction, alteration, or loss of original evidence seized pursuant to valid court-authorized warrants. Any uncertainty reflected in the government's present responses regarding the existence or accessibility of certain filtered or derivative working files does not undermine the integrity, completeness, or continued preservation of the original materials lawfully obtained and retained. The government's responses are offered to assist the court in tailoring any appropriate relief under 41G in a manner consistent with its equitable purpose, while preserving the government's lawful interest and constitutional responsibilities with respect to evidence obtained pursuant to valid search warrants and subject to independent preservation obligations. Wow, guys. Wow. Rather than require the government to return or otherwise divest its systems of the information, the government respectfully suggests that the more appropriate remedy would simply be to direct. A doggy came over here. Would simply be to direct the government to continue not to access the information in its possession without obtaining a new search warrant. So they're saying, look, you're having us move this stuff around, make copies, file it under seal in the EDVA. How about you just order us to not access it without a search warrant? This is why I made the comment at the beginning of this video that it seems like they're playing games. Playing some games with this. They're up to something. I'm not ascribing anything nefarious. I'm just saying they're up to something. It is not clear what Fourth Amendment interest would be preserved by ordering the return of copies of information that is already in the movement's possession, and that the government continues to possess, at least in the custody of a court or the DOJ's litigation security group, as may be appropriate given the presence of classified information. And the court's order properly recognizes that it is appropriate for the government to retain the ability. Here's the dog. What are they doing? There you are. And the court's order properly recognizes that it is appropriate for the government to retain the ability to access the materials in the future. Forcing transfer of evidentiary custody from the executive branch to the judiciary would depart from the traditional operation of 41G. The government respectfully suggests that the best way to do that is to allow the executive branch of government to maintain the information in its possession, rather than forcing transfer of evidence to. Man, this is like, okay, this reminds me of when you when you instruct your child to go do a thing, like clean up their room, and I want you to do this with your clothes, and I want you to do this with your toys, and I want you to take stuff off the floor and put it up on a shelf, like all these things, right? You instruct your child on the specific things you want them to do. And then they come back to you and you tell them they have until like 3 p.m. to do it. And then they come to you at 4 p.m. and you're like, did you do the things that I told you to do? And they're like, yeah. Like, okay, so you did this with your clothes. I'm like, well, I put them in the laundry basket. And okay, did you fold your clean clothes? Well, I took my clean clothes out and I put them on my bed. And all right, did you pick up your toys off the floor? Well, I put them over against the wall in one area because I thought blah, 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 blah. Like, okay, did you do this? Did you clean your ceiling fan, or did you dust or clean your windows? Well, we were low on paper towels and I didn't want to use the last paper towels to clean the windows. And my allergies are bothering me, so I didn't want to dust today. Like there's like this little, like I went a little ways and I went a little ways here and I have an explanation for this and an explanation for that. It just seems like it reminds me of that, where it's like a almost. It's like in every area with this, there's like, did you comply with the judge's order? It's like, well, we almost did. Also, we have a suggestion as to how the order should be modified, because that would, and modified in a way in which we don't have to do anything. And here's, they're playing games. Okay, and then they also want more time. They also want more time. Signed by Todd Blanche, but then also signed by Lindsay Halligan, still listed as the United States Attorney for the Eastern District of Virginia, even though she is not. Okay. So the judge had something to say about that. Okay, so Judge calling Kollar-Kotelly, what is it? Kollar-Kotelly has an order on December 19th. I think that's the same day as this motion, right? Yeah. Well, we're getting all this stuff on December 19th. Who knows when it's actually being entered, because court listener is, and Pacer is now well behind the activities of these courts thanks to the hack over the summer. She says in her order, yo, we got your motion for leave to copy this stuff and your emergency motion to clarify and your motion for an extension of time. The court shall resolve the government's motion at a later date as part of a broader order regarding the resolution of this case. In light of the concerns expressed in the government's motions, however, the court shall extend the government's deadline to certify compliance with the court's order of December 12th. Accordingly, it is ordered that the government's deadline to certify compliance with the December 12th order is continued to December 29th. So next Monday. No later than that time, the Attorney General or her designee shall certify with specificity that the government has complied with that court's order, or with that order of docket entry 20, which is the one that we went over at the beginning of this video and that we went over in the last video. It is further ordered that the government and its agents shall not access Petitioner Richman's covered materials or share, disseminate, disclose, or transfer those materials as it did when it transferred a complete copy of Richman's materials to a CISO in DC without leave of the court to any person without first seeking and obtaining. And she is not happy, guys. She is not happy. At present, in this second request, the court would benefit from an additional detail from Petitioner Richman regarding the government's imaging of his personal computer hard drive. In 2017, Richman consented to the government to seize his personal computer hard drive and make a copy. Footnote. Redacted. What is this spicy? What is this spicy morsel here? The court is requesting information as to whether the hard drive that Petitioner Richman consented to have imaged by the government was ever returned to him, and if so, whether any of the specified material had been removed from the hard drive that was returned. Accordingly, it is ordered that Richman shall inform the court whether the government returned his personal computer hard drive to him, and after it imaged the hard drive pursuant to his consent in 2017, and if the government did return his personal computer hard drive to him after it made the image. When they did so, whether any of the specified material had been removed from the hard drive. It is further ordered that Richman shall include this information in his response to the government's motion by Monday, December 22nd. So, what happened next? Well, quite a bit. And we're going to get to that in the next video. Hope you're enjoying following this case. It's getting more and more interesting. I'll see you in the next one.